light, but here we go. I just have a couple people left to admit. Quickly before we begin. Yeah, looks like we got all the parties connected. All right. Well, it's time to start. So let's get on the record. This is docket 6630 CG 140, the application of Wisconsin Electric Power Company for a CA, Certificate of Authority, for a new liquefied natural gas facility. My name is Michael Newmark, Administrative Law Judge, and we're here on Zoom for the pre-hearing conference. Our first task is identifying the parties, issues, schedule, and facilitating matters. So looks like we have the applicant and the potential interveners have all joined us on Zoom, and we can just begin. We have, I should do appearances first. So let me put the service list up on the screen here. So we got the appearances with the service list is the one that I have on file with the parties and their contacts that we'll use for serving commission documents in the case. Also, the list that parties and commission staff should use to serve each other. Let's start then in alpha order with Citizens Utility Board.
Good afternoon, Your Honor. Kara Coburn-Ferris with the Citizens Utility Board.
Okay, thanks. And Clean Wisconsin.
Good afternoon, Your Honor. Brett Cordy on behalf of Clean Wisconsin.
Okay, Public Service Commission.
Zachary Peters on behalf of the commission.
Sierra Club.
Megan Waxpress on behalf of Sierra Club.
Okay, Walnut Way Conservation Corp.
Mr. Westerberg here on behalf of Walnut Way. Good afternoon, Your Honor.
Well, and Wisconsin Electric Power Company.
Kate Phillips on behalf of applicant Wisconsin Electric Power Company. And I also have Patrick Proctor Brown from Quarles and Brady, also representing Wisconsin Electric Power Company. Thank you.
All right, thanks. All right, so we do have issues, schedule, and facilitating matters.
Your Honor?
Oh, did we miss? Oh, yes, we did miss somebody. Sorry. Did I not have you on the list? I think you're on the list. Oh, it's just alphabetically.
Right.
Yes, there we go.
Okay.
Industrial Energy Group comes after Electric Power Corporation. Go ahead.
Thank you. Steve Heinzen, representing the Wisconsin Industrial Energy Group.
All right, great. You guys need to change your name to like AAA. All right. So before we get to the issues here, I just wanted to clarify, just seeking some clarity here, because I noticed we had some a lag on the meeting confer. Looked like parties had not conferred until yesterday, and the notice did indicate that by November 22nd, we should have had parties and staff had met and conferred. And I don't know, I think everyone here is pretty familiar with this. Meet and confer can be something to the extent of like an email chain, just so people can share their ideas about the schedule and issues. But that didn't seem to happen until I think Monday after Attorney Peters had sort of initiated that. I think the applicant had complied with their indication, their position on staff's proposal by the deadline, but still, even that's not necessarily meeting and conferring. It's just one party expressing their view. So I don't know if do we need clarity on the process, or do people understand what we're looking for here to have a sharing of ideas by the deadline? Then essentially the assigned commission staff attorney is just going to indicate to me where we're at in terms of any agreement or any disagreement, just so we're more prepared for the pre-hearing. Does anyone need some more information on the process then, or is that clear to people? I mean, I would suggest don't wait till the deadline. Just get things started earlier so that we have just a snapshot of what parties and staff think about the proposal ahead of time. This notice actually did go out pretty there was a pretty big time in between errors, November 12th. So there was some significant time to get together and reach some sort of understanding. So you'll be seeing this quite, in every case. So just make sure we do a better job just getting that done ahead of time. All right, but anyway, I think we did have a productive meet and confer in the end. So it looked like there were no problems with the proposed issue. Is that understanding correct? Anyone can just chime in with a comment to the contrary. Anyone have a problem with the issue? No? Okay. And for the proposed schedule, looked like there was an alternative. So we'd have staff's schedules provided in the notice of pre-hearing conference. And then staff did indicate an adjustment was proposed. I think it was by Cub in the end. There was some agreement from, just gonna try to. There was some agreement from maybe all the parties, but definitely for some of the parties to an extension of the brief deadline. I didn't hear any complaints from staff about that. So did anyone want to comment on the current schedule and the schedule as modified, proposed by Cub to change the brief dates?
Your Honor, this is Kate Phillips for Wisconsin Electric Power Company. We have no objections to staff, to the Cub's proposed adjustment to the briefing schedule.
All right. Anyone else want to? Yeah.
Sorry, I just wanted to jump in real quick because I had understood them to be proposing, Cub to be proposing April 17. So instead of 12 days, 14 days. And I see on the screen April 29, which would be, I think, 26 days.
Oh.
So
We actually proposed a minimum of 2 weeks, understanding that the commission has, a complex schedule to work with. So those suggested modifications work well for us.
Staff want to clarify at all about the proposal?
I don't know that there's, I mean, clarity from the parties is helpful on what was intended or what was needed. I'll say, I think from staff's perspective, if there is an earlier date that was proposed and is acceptable from that April 29th, I think that would be appreciated from staff's perspective. If it wasn't intended to be pushed all the way back to the 29th, and we can bring that back a bit, I think that would be fine. Though I do think that staff can make the dates as they appear on screen work. If that wasn't intended to go quite that far, I think staff would be appreciative of bringing it back a bit. So I don't know what was the intention of the proposal.
Okay, well, and this is the dates I have from staff. So if staff wanted to propose a different date, I guess I would have been willing certainly to have reviewed that. But if staff doesn't have a proposed date, I'm just going to go what we have on the screen.
That's fine.
Okay, all right.
thank you, Your Honor.
So I'll then incorporate that into the pre-hearing conference memo. Are there any questions with the facilitating matters order? Anything coming to anyone's mind here? I did want to mention there may be some confusion about errata filings, and I don't know if it's completely fleshed out in the document, but I think our practice, we're expecting people to do here in terms of errata is when there's errors in a filing, like testimonial filing, an errata be submitted that shows the original text that needs to be corrected, and then the proposed correction as a simple line by line sort of indicator. That way parties and staff, the other participants have a heads up as to what the mistakes are in a previous filing, what the corrections are proposed to be, and then they have notice of that proposed correction. We take that errata all the way to the hearing, and then at the hearing, there's an opportunity where we accept the errata, and then I order that a refiling be made by the deadline, and that the refiling incorporate the errata, the part of the errata that's been accepted. Changes to testimony other than these sort of typos, mistakes, what would normally be put in an errata document, changes to testimony, changes in a witness's position or an additional issue addressing some new information. That's properly filed as supplemental testimony. So for example, if you filed a direct and then time has gone by past the deadline and there's something new that's come up, the party or staff would need to file a supplemental direct testimony with that new information. And along with it, there's a process for requesting leave to file that, because now the opportunity to respond may have changed, the timing has changed, so that we need to work out some way to make sure that the other participants can respond appropriately. So there's a difference there. I wouldn't necessarily expect to see, or I shouldn't expect to see, refiled testimony be made during the course of the schedule. We're going to see testimony filed according to the schedule and errata upon finding some sort of mistake to testimony. But if something new has to be testified to, it's either going to be in another round of testimony if it's responsive, or if it's something new, it should be in supplemental testimony. So I just wanted to clarify that, make sure people understand the distinction there. And just this is really coming from recent filing. I think it was 6630 CE1, CE 317. There was a revised testimony filed. I'm not really sure. I haven't looked into what the difference is between the past testimony and the new testimony. We don't need to get into it here, but I just don't think that's really what's envisioned in the process. Maybe there's some reason why we wanted that filed, but I wasn't asked, and I don't really know what that is. So just so you know, when you're filing these things, there's you file according to the deadline, file errata, and file supplemental testimony. Those are your options at this point. If there's some sort of extraneous circumstance, we need to make some sort of exception, that can be done, but we need to be asked, that needs to be asked for and needs to be granted. So so we'll see what happens in this case. It's always a surprise. So otherwise, that's all I can think of in the FMO. I don't know if there's any concerns anyone else has about this, or anything about the facilitating matters people want to discuss. No? Okay.
Your Honor, I'm looking at the schedule right now on the errata, and it looks like the dates might be flipped there for the surrebuttal and errata.
Oh yeah, look at that. That's right. Well, let's see what we have for. Yeah, so the errata is usually going to be a day or two before the party session. So yeah, that should be. It's probably just flipped. I don't have the current proposal anymore in front of me. Here it is. Okay. Yeah, okay. Surrebuttal on 325. Yeah, I'll use what's showing in the screen share to make the pre-hearing conference memo and set the schedule in our system. So no worries. The one that's in the notice pre-hearing conference will be superseded by that. So glad you you'll notice that.
And then on your errata discussion a moment ago, it wouldn't preclude anyone from filing errata early if it came to light that it needed to be filed. So
Yeah, I think
those changes can be made, right?
right. Best practice is upon finding a mistake, file an errata. You can file as many erratas as you want, but give people the opportunity to see it ahead of time. You know, it may affect the next round of testimony too. So if you understand there's a mistake, you can get it in, and then the next round isn't confused by the mistake that's in the prior filing. We just want to get, you know, to the best we can, get the errata filed in writing and in our hands before the hearing starts. This way, parties and staff, you know, the other participants have the notice of the change before the hearing. When we accept the documents, we're all on the same page. Or maybe there's a problem with the errata. Maybe there's some contested fact that's now being changed, and we need to vet that at the hearing. That's what the hearing's for. So yeah, to get that errata in before the hearing, and you know, anytime you find a mistake, best practice is to file the errata as soon as you know.
Thank you.
So yeah, thanks for pointing that out.
So, Your Honor,
Mhm.
if I could, thank you. Not to go through every possible example that we can, but I will just ask this one. You have a witness says it's $20 million. It's actually 35 million. That's an errata and not anything other than an errata.
If that's the only change, if it's,
Yeah.
I still think it's way out of the ballpark. You know, if this changes your conclusion,
No, it's just a math.
then
It's
yeah.
just correcting the math.
If it's just, you know, there's a switch in the numbers. Yeah, I mean, that's why it's errata. At least gives people the advance notice that you're changing the number. Didn't change your position, but the number was filed incorrectly. I think that's still errata. I mean, of course, there's going to be there's always going to be some example that's going to mess it all up, but that's the idea. That's the concept. Yeah, if you change, or if there's a reason why the numbers changed, well, then, you know, there's a new estimate to the blah blah blah. Well, now we're talking about new testimony. You're really talking about why do you think it's changed, and what forces acted on changing changing the number. Not you just, you know, you misread it, you transpose a number. And
Thank you so much.
yeah, sure. Okay. Any other examples? All right. Well, sounds like we're good. I think that's all we need to discuss. Anything else before we adjourn? Anything from anybody? Well, hearing nothing. All right. Thanks very much, everybody. We're adjourned. I'll get that Prehearing conference memo out soon. So thanks and take care.
Thanks, Your Honor.
Thank you, everyone.